The Minnesota eviction notice. What is an eviction notice? Eviction notice, or notice to quit, is a letter sent by the landlord to the tenant notifying them that they should either take or stop a certain action or vacate the rented premises. Eviction notice can be of two types: conditional, when a tenant is given time to remedy the breach of the lease, or unconditional, when a landlord terminates the lease without any alternative options for a tenant. What should an eviction notice include? Information about the tenant and the landlord. The reason for sending the notice. The date by which the tenant should take or stop a certain action. The consequences of non-compliance. The date and way of notice delivery, and the landlord's signature in the form of certificate of service attached to the notice. How to evict a tenant in Minnesota. Non-payment notice. There is no statutory grace period for rent payment in the state of Minnesota. This enables the landlord to send the notice to the tenant the very next day after the rent is due, unless otherwise stated in the lease. The Minnesota legislature gives the landlord the right to send a 14-day notice to quit to the tenant at will, who is the tenant occupying the premises without a written lease or with a contract without an end date. In case of all other tenancies, the landlord is not required to send a notice prior to evicting the tenant for non-payment of rent according to Minnesota laws. Non-compliance notice. As with non-payment of rent, the Minnesota landlord is not required to give the tenant time to correct the issue if the tenant violates other terms of the lease. But a prior notice before the start of the eviction process is one of the state's requirements. The state law does not set a notice period, though. What if the tenant fails to comply? If the landlord aims at starting an eviction proceeding, they should file a complaint with the appropriate Minnesota court. The filing fee will depend on the county. For example, in Douglas County, the fee is $295. Then, the summons and complaint are to be served on the tenant by a person not involved in the court case at least 7 days before the hearing. In case of eviction for illegal activity, it should be done within 24 hours of the date of the summons issuance. The tenant's failure to appear for the hearing might result in a judgment in favor of the landlord by default. If the landlord wins the case, a writ of recovery will be issued. According to such an order, the tenant has to move out within 24 hours after the document was delivered to them. But if the tenant is evicted for any reason except for illegal activity, they have the right to request a 7-day stay of execution if moving out immediately would create a hardship for them.